Triple Talaq held unlawful. Supreme Court of India delivered a historical judgment in the matter of Triple Talaq in August 2017. Triple Talaq, also known as Talaq-e-Biddat, is a practice of instant divorce used by Muslims in India. The use and status of Triple Talaq had been subject of controversy and debate. Triple Talaq had raised issues of justice, gender equality, human rights and secularism. The debate was also in many ways connected with the debate on Uniform Civil Code. And in August 2017, in a historical judgment by a bench consisting of multi-faith, 5 judges, by a 3-2 majority held that 1400-year-old Sharia practice is unconstitutional and violative of Muslims' women's right to equality. The majority in the 5 constitution bench of Supreme Court said this form of talaq is manifestly arbitrary in the sense that the marital tie can be broken capriciously and whimsically by a Muslim man without any attempt at reconciliation so as to save it. This form of talaq must therefore be held to be violative of the fundamental right contained under Article 14 of the Constitution. By declaring Triple Talaq unconstitutional, the Supreme Court overturned an earlier 85-year-old judicial decision, that was in 1932, which had upheld the validity of the controversial practice. This judgment had permitted a Muslim man to instantaneously divorce his wife, and in 1932, the Triple Talaq had come up for scrutiny before the Privy Council, even before the formal British rule came into existence. Subsequently, there was also a historical judgment of the Supreme Court, and even before this historic judgment of the Supreme Court, there have been High Court decisions by Kerala High Court, Guwahati High Court and Delhi High Court, and all these High Courts had said the practice was not valid, but they stayed short of declaring Triple Talaq unconstitutional and did not ban the practice as such. Now let us see the highlights of the judgment. Supreme Court held that practice is arbitrary as a marital tie can be broken capriciously and whimsically without any attempt at reconciliation. Second point was that Triple Talaq is only one of the permissible forms of divorce in Islam, stated to be sinful by the very Hanafi school that tolerated it. Supreme Court also held that the Triple Talaq is arbitrary and violative of the Article 14 of the Constitution. Further, Supreme Court also held that Triple Talaq lacks legal sanctity. It further said, merely because the practice has continued for a long, and that by itself cannot be make it as a valid. As regards dissenting remarks by the 2 judges, the following points were noted. These 2 judges said that the law recognizes Triple Talaq as a part of Islamic personal practices. It is because it has been followed by the Sunni Muslims of Hanafi school for 1400 years. Now, it also said, the dissenting remarks also said, Triple Talaq is also part of a right to religion guaranteed under Article 25, and it does not violate Article 14, 15 and 21. Further, the judges also said, as a part of the personal law, Triple Talaq has a stature equal to fundamental rights, and therefore courts cannot set it aside. Further, government should enact a law if it wants, banning a triple talaq as it had done for Sati and Devdasi system among Hindus earlier. Till such law is enacted, no Muslim can use triple talaq route to get an instant divorce, and unfortunately the union government has sought our hand, and that is basically a field which truly falls in its own area. As said earlier, there has been enough background for the triple talaq case that was brought before the Supreme Court. Background to this judgment was that it was 5 women who led the fight against practice of triple talaq in the Supreme Court. The triple talaq practice has been challenged on the ground that there is a law by the Center for the Right to Life, Liberty and Dignity which is guaranteed under Article 21. Further, instant divorce weapon was exclusively given to Muslim men, but the Article 14 provides for equality before law and non-discrimination. The petitioners, the 5 women, therefore attacked the constitutionality of triple talaq practice. Women organizations say that they routinely receive a complaint of dowry harassment, violence and abuse, at the end of which Muslim women are summarily sent packing with the triple talaq, even sometimes through WhatsApp messages, newspaper advertisements and scribbled on a pieces of paper and even at times conveyed over the phone. Triple talaq was also criticized on the ground that no woman, regardless of status, is ever safe. Most Muslim women are acutely aware that their married lives are finally balanced and there is some fear always. Unlike other communities, they felt they had no protection from the law. Such instances are more pronounced in cases where literacy and awareness levels are low, and where women are more susceptible to being made fear consequences under Islam. Sometimes Maulvis and Maulanas can play very deeply disruptive roles. In a patriarchal setup, many women who dare come forward to complain of abuse or instant triple talaq are made to fear the very religion that ought to have protected them. According to Times of India report, there are more Muslims divorce, whereas Hindus prefer separation. There have been many reactions to the judgment since the triple talaq issue is surrounded by controversies. But overall, the judgment has been hailed across all sections of society, including the Muslim community. It is because it grants equality to Muslim women and it is a powerful measure for women empowerment. While declaring triple talaq as an unconstitutional practice, the Supreme Court's 5 judgment by majority decision has said personal laws of every religious denomination enjoyed the status of fundamental rights and they could not be invaded by the government. Supreme Court very specifically said personal law has constitutional protection. This protection is extended to the personal law through Article 25 of the Constitution. It needs to be kept in mind that the stature of personal law is that of a fundamental right. Further, the All India Muslim Personal Law Board and Muslim outfits took a stand that government could not interfere with personal laws. This was the argument put up by the Muslim personal law boards before the Supreme Court. But the judgment stressed the point that the government was competent to reform personal laws on grounds like public order, health, and morality. There are exceptions which have been provided for under Article 25(2) of the Constitution. This leeway, therefore, can be used by the government to try to carry out changes in the personal laws in order to bring a social welfare measure in the society in general. The court also asked the centre to take steps to codify Muslim personal law, especially to eliminate triple talaq by enacting a law. But 3 of the 5 judges also on a bench said the government can interfere with religious laws, and notably they said the triple talaq is not a part of Quran as such. Now let us take a look at the types of talaq that exist. Supreme Court verdict dealt with the practice of talaq-e-biddat or instant divorce. This talaq method is one of the 3 types of talaq, that is, divorce initiated by the husband in Islam. The other 2 are talaq ihsan, that is a pronouncement followed by abstinence of 90 days. And the third one is the talaq hasan, where 3 pronouncements are made over 3 months. According to the petitioners, the judgment will prevent hundreds of women from the same ordeal.